Assalamualaikum and greetings to our respected lecturer, Dr. Zabri. I am Rizal Kristina, 82044417. Together with my teammates from Group 10, will be presenting to you our assignment with the topic of Accidental Killing or Criminal Act, a cooperative study of Malaysia and India. Our group consists of 3 members. Now, let's dive deeper into the study. To start, I would like to introduce why we discuss the defense of accident under Section 80 of the Penal Code as applied in Malaysia and India. This provision protects individuals from liability when an act results in accidental killing, provided it is done without intent or knowledge, while performing a lawful act in a lawful manner and with proper care and caution. In the Malaysian case of Tok Peng, the Malaysian court rejected the defense of accident because the act occurred was unlawful, which is robbery. Carrying a knife showed intent and foreknowledge of harm, making Section 80 is inapplicable. So, Malaysia adopts a strict interpretation to ensure accountability, especially in cases involving premeditated action. By right, in contrast, in states of Gujarat case, the India court upheld the defense when the accused mistakenly shot a human believing it was hyena, but it happened during a lawful hunting. The act was ruled purely accidental because with no intention or negligence. So India has showed that they have an flexible approach which is considered that intent and circumstances ensuring fairness in genuine accidents. So I will pass to the next presenter.
Assalamualaikum and hi everyone, my name is Siti Nur Alina Afifah. So we are going to discuss for the next part, which is the issue analysis and the elements in order to raise a defense of accident under Section 80 of the Penal Code. According to the Section 80 of the Penal Code, it was not an offence if it happens by accident or misfortune with a criminal intention or negligence. The act must be lawful done in a lawful manner with proper care and caution. The meaning of accident was an event that was unexpected and not intended to cause harm to other person. Meanwhile, for misfortune, it was an act that occurs with the intention or negligence, which is an avoidable event without human intervention. Furthermore, in raising the defense of accident, there are 4 elements in defense of accident and must be proved in order to success in this defense. Firstly, the act was done by accident. Secondly, the act was done without criminal intention or knowledge. And the third one, the act was done while performing a lawful act in a lawful manner. And lastly, the act was done with proper care and caution. There is several cases that can be referred to on how the elements of defense are applicable or discussed in raise the defense of accident under Section 80. For the first element, can be looked under the case of the state against the Rangaswamy 1952, which is that in this case, the accused mistakenly shot a person thinking it was a hyena. The court accepted the defense as bona fide because the intention was to protect people from the hyena. And this element in the case of the Tunda against State 1950, which is that during a race match, the accused accidentally caused the death of a friend, which is that the court ruled that there was no premeditated intention or criminal purpose, granting protection under the defense of accident. Moreover, in the case of the Jageshwar against Emperor 1924, which is that in this case where the husband accidentally caused the death of his child during the fight or dispute with his wife, so the court ruled that the act was not lawful despite the accidental nature, as the action leading to the accident were not lawful. And for the last element, in the case of the Bhupendra Sinha Chodasama against the state of Gujarat, a constable accidentally shoot a head constable during patrolling duties, so the court held that the act left with proper care and caution does not qualify for the defense of accident. It has to be looked at the burden of proof rests with the accused, which is the person or the accused need to demonstrate the validity of the defense. The action of the accused will be a critical factor for the court in determining whether the offence was committed in good faith or in a lawful manner.
So now let us discuss the challenges in applying Section 80 to accidental killing cases. The first challenge that we face is how do we prove the lack of intention in criminal offences. Mens rea or the culpable mental state is a key element in criminal offences. According to the case of Sweet and Parsley, it highlighted that mens rea is essential unless explicitly excluded by the Parliament and emphasized that the difficulty in proving intent or knowledge in criminal cases. On the other hand, proving a lack of intent under the defense of accident requires the prosecution to establish beyond a reasonable doubt that the accused acted with intent or knowledge, while the defense must create reasonable doubt. As in the case of public prosecutor against Daniel Lonaturkan, where the court found that the prosecution failed to prove the accused mens rea. To succeed under Section 80, the accused must show the act was accidental and lack of criminal intention or knowledge. This intent differs from subjective mental states required for specific offences, which complicating its proof in court. We have a case example which is Ratnam against R. In this case, the accused's claim of an accidental stabbing was accepted, overturning a culpable homicide conviction. The court ruled that the act was unintentional and accidental, underscoring the necessity of proving mens rea for such offences. The second challenge is how do we differentiate between accident and negligence. So firstly, let us look into the legal definition between these two phrases. So accidents are unforeseen, unintentional events, while negligence involves a failure to exercise reasonable care to prevent unforeseeable harm. The court must assess reasonable foreseeability and precautionary measures to differentiate between these two. We have 2 scenarios as example. Firstly is road traffic scenario. Accidental killings occurs when the harm is unavoidable despite lawful actions. For example, a driver hitting a child who unexpectedly darts onto the road. Negligence involves reckless behavior as in R against Walker, where excessive speed led to a fatality and a manslaughter conviction due to recklessness. The second scenario we use is hunting scenarios. Accidents arises when precautions are taken but harm occurs unexpectedly, as in King Imperial against Kiamapa, where a hunter unintentionally killed his companion, and negligence occurs when proper care such as verifying target is ignored. As for challenges in Section 80, the provision safeguards against undue punishment for genuine accidents, but faces challenges in proving the absence of intention and distinguish accidents from negligence. Judicial analysis and compelling evidence from both prosecution and defense are critical to fair applications.
For this part, we will look for the two cases, which is from Malaysian cases and also Indian cases. For the Malaysian case, in the case of the Tok Kian Peng against the public prosecutor, the issue in this case was whether he was guilty of murder under Section 302 of the Penal Code, and if his defense of a sudden fight at Section 4 to Section 300 of Penal Code or accidental stabbing under Section 80 of the Penal Code could mitigate the charge to a lesser offence. So in the High Court, the court held that the accused was convicted of murder under Section 302 of the Penal Code. There is evidence from the witnesses that saw the accident occur. The accused claimed that during the sudden fight was accidental, as the accused was only to rob the saloon but not to kill. So the High Court determined the stabbing was deliberate, demonstrating intent and also malice, and sentenced the accused to death. In the Court of Appeal, the appeal was dismissed under Section 80 of the Penal Code can be applicable in this situation because the action of robbery was unlawful, which is against the elements of the Section 80 of the Penal Code. So the court affirmed with the decision of the High Court, and exception 4 to subsection 300 did not apply as the intent to cause harm during robbery was clear. Moving on to the next part, which is we will look at the India case where the race of defense of accident was successful, which is in the case of the state of Gujarat against Rangaswamy 1952. The issue in this case was whether the accused were guilty of criminal rashness or negligence under Section 304 capital A of the Indian Penal Code for accidentally shooting the deceased. And secondly, whether his defense under Section 80 of the Indian Penal Code, which is accidental acts performed in good faith, was valid. And lastly, whether the fine for using an unlicensed firearm under Section 90 subsection E of the Indian Arms Act should be increased. This case illustrates where the accused wanted to shoot Hina to protect people from it, and during that day it was a rainy day and there is a sound, which is that the accused believed that it was a Hina. Unfortunately, the accused mistaken and shot the deceased and causes death. The court concluded the shooting was accidental and not indicative of criminal negligence or recklessness. Section 80 of the Indian Penal Code was applicable and protecting the accused as he acted in a good faith without intention to cause harm. So the fine for the breaching the Indian Arms Act was deemed adequate and was not increased, and therefore the accused was acquitted under Section 304 capital A of the Indian Penal Code.
So how do we analyze this critically? We shall see how Malaysia and India approach the defense of accident under Section 80 of the Penal Code itself, through focusing on two key cases, which are Tok Kian Peng against public prosecutor in Malaysia and State of Gujarat against Rangaswamy in India. In comparison, the key differences lies in the interpretation, where Malaysia emphasised accountability, especially for acts type of unlawful activities, while India prioritized fairness, giving weight to the lack of intent and context. This distinction highlights how Section 80 requires not only the absence of intent, but also that the act itself be lawful and carried out with proper care and caution, ensuring the provision cannot be misused in cases involving premeditated or reckless behaviour.
Now, we also provide some recommendation for Malaysia to improve the application of Section 80 of Malaysian Penal Code in cases of accidental case. So, first point, we will see that contextual case evaluation. Courts should carefully assess the intent and negligence of individual to differentiate deliberate crimes from accidental outcomes. This ensures that legal interpretation considers the broader context and specific circumstances of each case. And the second point will be legal education and public awareness, whereby public education is crucial to reduce risky actions. Why? Because this program will be able to be introduced to the people as to teach the people about the consequences of their act and behavior. It focus on the rural areas, whereby this awareness campaign can help the citizens better understand the law and prevent unintended offences. Last but not least, impose the Justice on Wheels initiative, whereby it has been done. By expanding the programs like this, it will enhance legal literacy, whereby these initiatives help citizens quickly understand their rights and legal consequences of their actions, promoting information and more awareness, especially to the society. So, by adopting this recommendation, Malaysia can improve fairness in applying Section 80, ensuring individuals involved in genuine accidents are protected.
We also provide the recommendation to improve this application of Section 80 of the Indian Penal Code regarding accidental act. So the first point will be the Indian Penal Code shall clarify the definition of lawful act, use the ambiguity and clear guidelines, as well as examine what constitutes a lawful act. This will help both the public and the judiciary understand the boundaries of lawful actions. Second point would be we shall exclude recklessness and gross negligence, because this immunity under Section 80 should not be applied to acts involving recklessness or gross negligence. For instance, if someone claims an accident but acted carelessly, they should not be allowed to escape liability, explicitly stating this can prevent misuse of the provision and maintain its integrity. Third, Indian Penal Code must maintain integrity of the law itself, because it is so crucial to strike a balance between protecting individuals involved in genuine accidents and holding people accountable for carelessness. Aligning legal provisions with principles of justice and fairness ensures that the law remains effective and trustworthy. However, these recommendations can help improve clarity, prevent misuse, and ensure fairness in handling accidental cases under Section 80 of the Penal Code itself.
In conclusion, Section 80 of the Penal Code provides immunity for accidental killing during lawful acts done without criminal intention. However, vague terms like accident and criminal intention led to inconsistent judicial interpretation, which will complicate the fair applications. We have applied cases such as Tor Kian Peng against Public Prosecutor and State of Gujarat against Rangaswamy revealed the difficulty courts face in defining lawful acts and accident, which results in inconsistent rulings and unfair outcomes for both defendants and victim. There are clearer definitions for key terms and specific criteria for accessing accidents could reduce subjective judgment. Legal juries suggest that we can amend Section 80 by integrating it with Section 76 and 79 to streamline defenses of mistake and accidents. Besides that, training for legal practitioners and public awareness campaign would improve understanding and application of Section 80 and ensure fairer trials and restoring public confidence in the legal system. That's all for our presentation today. Thank you so much for your kind attention.